Well, good morning, everyone, and welcome to another Radcliffe Talks Real Estate webinar. I'm Matt Mills, and I'm delighted to be joined by Mike Ellis, Senior Associate in the Property and Commercial Litigation team at Wilson's Solicitors. Good morning, Mike.
Morning, Matt.
For those of you that don't know, these webinars are meant to be slightly less formal than your standard presentation. For example, there are no slides, there's no handout, and there are no ties either. Instead, Mike and I will be discussing in a Q&A form property litigation in a COVID-19 world. We hope to cover quite a lot of ground this morning, pretty much from pre-action to remote hearings. So without further ado, I thought I'd kick things off by asking Mike, what types of questions have property owners and occupiers been asking you since lockdown began?
Thanks, Matt. Well, most of my clients who have asked about the impact of COVID have been landlords, but I do also have some tenant clients who are also inquiring about the effects of COVID on their property affairs. I act for a mix of commercial and residential landlords and some residential tenants as well. On the landlord side, the main question has perhaps obviously been, how do I get my tenant out of the premises? Which, as you might guess, has then prompted a long discussion about the effects of the Coronavirus Act and Practice Direction 51Z. On the tenant side, this has made giving advice to clients very straightforward. Everyone has been asking me how long these restrictions are likely to stay in place for. And this has been impossible to answer, really. The restrictions, when originally introduced, were initially designed to stay in force until more or less the end of June. But since then, of course, they have been extended practically to the end of August. It's possible that there may be a further extension after that too. I'm sorry, was I boring you there, Matt? You disappeared for a second. There is then the issue of the backlog of court cases. With an overstretched judiciary and limited facilities to hear cases efficiently and quickly, I can imagine that this is going to prolong waiting times once proceedings are eventually able to get underway. So I think the knock-on effect is going to be significant, and we could be seeing matters, pushed back a long time. My landlord clients in particular have been asking what can be done in the meantime. And really the answer to this question, the answer to the question of getting possession is that there's very little that we can do. Yes, there are still mechanisms available for recovering rent arrears, but really my landlord clients just want possession. And at this stage, there is very little I can recommend legally.
That's interesting, because I've only been asked to advise one client about possession proceedings during lockdown. So it sounds like you're fielding all the questions for me. So thank you very much. Changing topics slightly, the Land Registry has recently published draft guidance suggesting that it will soon be accepting electronic signatures on certain documents. Do you think that will be a good thing for conveyancers?
Okay, so yeah, this is the recent announcement made by the government, which, as you say, came out on the 9th, about 2 or 3 weeks ago, and published on the Land Registry blog page. And that followed on from the Law Commission report, which I think was published last year on this issue. And that itself was in response to a consultation which has been going on for some time on this matter. So it's good to see at long last some recommendations now being implemented, particularly given the current COVID landscape. In answer to your question, yes, I think this is good news for conveyancing. The announcement has confirmed that the Land Registry will soon be able to start accepting what you and I know as an electronic signature on documents that are to be executed. And so that is designed to be basically a direct replacement for a wet ink signature. It's been recognised, of course, that the coronavirus outbreak has made it jolly difficult to execute documents in front of witnesses. And I can speak from personal experience on this point, as not long into lockdown, I had to execute a transfer document at home. Fortunately, my very kind neighbour was willing to assist from across the garden fence, from a safe distance, of course, but it was still a clunky and uncomfortable situation to be in. Just drilling down into what electronic signatures are, there are in fact two species, if you like, And I think it's good to know what those differences are. The first is, it's called a digital signature, and there are two sort of sub-forms of those, which I won't go into now, but those have been around since 2002. The second category is really the replacement substitute for the wet ink signature, the sort of more urgent need to introduce that being the cause for the land registry update. Just going back to that first category signature, the digital signature, this is something which requires the parties to follow a specific process, which has a way of identifying that the correct person is signing the document. The process then results in the document being encrypted, and one of the advantages of this is that it doesn't require a witness. Practically, I haven't personally seen this being used very much at all, but really coming back to the main purpose of this announcement, and coming back to what you and I generally know as an electronic signature, it's good news, I think, that the land registry will be prepared to accept these. And I've also just seen that they've issued a draft practice note. I've had a quick look at that, and it looks quite sensible and pragmatic. There are some limitations, as you might expect. Parties must be represented by conveyancers, and they have to use a platform through which the document is controlled and signed. So it's likely to be a little bit clunky to start with, but with time, I'm sure practitioners will get used to it. And ultimately, I think it will enable conveyancers to streamline their services. I think it's important to remember that whilst these new advances are good news, the land registry guarantees title to all of the registered land, and so it needs to strike a balance between efficiency and security. So when implementing these steps, it needs to make sure that it doesn't expose itself to a greater risk of fraudulent transactions taking place.
What seemed to me is that this might be particularly useful for companies, because to execute a deed, companies don't always need to have their signatures witnessed. So this might help them there, where they can literally do this on their own in a COVID world. But moving more to the realm of litigation then, how have you found dealing with litigants in person and tenants in the last few months?
Well, being at the coalface of these sorts of inquiries, yeah, there's been many inquiries. In all of the cases I'm dealing with where I'm acting for landlords, tenants are unsurprisingly taking full advantage of the restrictions imposed on landlords. And more often than not, I'm finding that tenants are unrepresented. I'll give you a case as an example. I'm acting on a matter where we act for a commercial landlord. The tenant is an individual. It's a mixed use premises, so it has a residential aspect. Our clients obtained a possession order pre-COVID lockdown and before the rules came into force. Now, the effect of this is that my clients are now basically prevented from taking any action whatsoever to get this tenant out, and the tenant has flatly refused to engage or take any steps to comply with the court order. So I'm finding a lot of obstinate tenants, and I'm finding a lot of frustrated landlords. All of the circumstances that I've come across have been tenant default matters where I'm acting for landlords. So we're looking at either forfeiture or Section 8 in a residential context. I've also found that overwhelmingly the reason for tenants defaulting under their agreements has been non-COVID related, so pre-existing issues for those tenants. On the flip side, I'm also acting for residential tenants, and in one particular matter, a client has been served with a notice, and he is more than happy to play the game. his landlord is precluded from taking action because of the rules. There's an argument that the notice which has been served has been defective, but actually, do we want to raise that? Probably not, because all we're going to do in doing so is to alert them to the risk that their notice is defective, and they may well just serve a further notice. So the client's best interest to serve by not saying anything about that. But that's a salutary warning to make to other practitioners that because the timescales involved at present are extended, the consequences are much more serious if you have a defective notice. And of course, defective notices is a fertile ground for profit neg claims. So I would urge everyone to take extra care in getting your notices checked. I think I've done enough talking for the moment, Matt. So I think it's time for you to answer a question. And what I would like you to explain to me are the restrictions which apply to serving Section 8 and Section 21 notices.
Sure. So in my view, this is quite an important issue, which is often lost in the noise surrounding the stay on possession claims. So my first real tip is don't forget these changes, because we've got both new law and new guidance here. Starting with the law, in a nutshell, Schedule 29 to the Coronavirus Act confirms that both Section 8 notices and Section 21 notices must now give a tenant at least 3 months' notice to leave the property, not just 2 months. Now, this extension applies for what is called the relevant period. It's a phrase that comes up a lot in the law that's been introduced since COVID, but it basically refers to the 26th of March to the 30th of September. However, the government does have power to extend that period in pretty much any act or rules that relate to it. On top of that, in this case, the government can even extend the amount of notice which a landlord must give a tenant, so it can go from 3 months all the way up to 6 months. Now, as far as I'm aware, the government hasn't given any indication that it would do this, but it's important to bear in mind because it will be one way for the government to start to, for example, ease the restrictions on possession proceedings, but increase the time that must be given in a notice. Now, the guidance doesn't add much detail to what I've just said, but it opens with the following words, which are highlighted in bold on a page of their own. And it says, "We strongly advise landlords not to commence or continue possession proceedings during this challenging time without a very good reason for doing so. It's essential that we work together during these unprecedented times to keep each other safe." Now, while that's quite a sensible, fair and emotive message from the government has nonetheless updated Form 3 and Form 6A, at least for properties in England, for landlords who do still intend to serve a notice. So my second tip for you is don't forget to update your precedents, or at least download the new forms if you're considering serving one of these on behalf of your client. Now, that said, it's important to bear in mind that these rules don't affect notices served before the 26th of March and don't prevent a landlord bringing a debt claim against a tenant. But apart from that, that's probably about as much as most residential landlords would be able to do right now. For example, the government has introduced restrictions on enforcement agents in the residential context, in what is, in my view, the snappiest titled law of the lockdown period, which is the Taking Control of Goods and Certification of Enforcement Agents Amendment Coronavirus Regulations 2020.
That's very snappy. Thanks for that, Matt.
That's all right. But speaking of Section 21 notices, Mike, one of the big recent cases in property law concerns gas safety certificate. Now, on the 18th of June, the Court of Appeal handed down a judgment on this point in the Trecarrell and Rouncefeld matter. What was that case about?
Yes, so this is a long-awaited decision, and this followed on from the Corridon decision from 2018, which held that a landlord couldn't serve a valid Section 21 notice if the tenant hadn't been served with a safety certificate prior to the commencement of the tenancy. I think it's going to be helpful just for me to run through the background facts very, very quickly. Mrs. Rouncefeld, she was an assured short-hold tenant of a flat in a block, lovely property in St Ives in Cornwall, overlooking the sea. Her tenancy started in February 2017. She didn't have any gas appliances in her property, but the hot water supply and the central heating was heated by a boiler housed elsewhere in the building. Now, her landlord had in fact obtained a gas safety record in January 2017, so a month before the tenancy started, but this was never provided to the tenant prior to her tenancy starting the following month. She was ultimately served with a copy in November 2017. Fast forward, and the landlord then serves a Section 21 notice, issues a claim, tenant fails to move out. Tenant defends on the grounds that no gas safety record was supplied at the start of the tenancy and that the Section 21 notice was therefore invalid. Judge agrees disagrees at first instance and gives the landlord possession. Mrs. Rounsfield then appeals, and the circuit judge reverses that decision, essentially on the grounds that it was impossible to perfect that defect. There is then a subsequent appeal to the Court of Appeal, and with a majority of 2-1, the Court of Appeal decided that providing the landlord, providing a certificate had been obtained by the landlord prior to the commencement of the tenancy, it didn't actually matter that this wasn't provided to the tenant prior to commencement, so long as it was provided before a Section 21 notice was served. So that's helpful, I think, because it does mean that landlords who have got their affairs in order pre-tenancy, but who forgot to serve the notice, the gas safety record before the tenancy started, can perfect that defect. But it doesn't answer all the questions that are possibly raised. In particular, what about landlords who, in fact, fail to obtain a gas safety record or certificate prior to the tenancy starting? Can they actually serve a valid Section 21 notice? And I think, looking at the reasoning and the decision, that they probably can't. Now, is this the right outcome? I think yes, it is. I'm obviously boring you again, Matt, because you've disappeared, but I'll keep talking. Now, there is a tremendous amount of red tape involved in letting properties under assured short-hold tenancies. And even for the most experienced practitioner, it can still be a minefield figuring out whether a landlord is able to give a valid Section 21 notice. I get that there is a good reason for gas safety records to be in place, but there are other consequences to not giving a gas safety record in line with the regulations. It's a criminal offence for a start. But what I'm going to do is I'm going to preempt a question that Matt, I'm sure, would like to ask me about a recent mediation that I've recently experienced. This was one which was initially intended to take place pre-lockdown, and then, of course, the lockdown happened. When that happened, it was decided that we wouldn't go ahead with the mediation because it was felt that a site visit would be necessary and useful. Now, as the lockdown continued, all of the parties agreed that it would be useful to continue with the settlement discussions, and we were able to set up a mediation via Zoom. It took a lot of effort to set it up, but with a lot of effort from all of the parties, it went ahead. Now, it was originally envisaged by the parties that a site visit would be necessary for the mediation to be able to go ahead. And actually, we realised that that wasn't necessary, and the mediation could still go ahead, albeit over Zoom. Now, it did present some issues on the day. I was dealing with a litigant in person on the other side, and that made it very, very difficult to effectively hold a successful dialogue. The confines of working remotely mean that it's much harder, I think, to develop that rapport in a discussion. But ultimately, it was able to go ahead, and I don't think the mediation suffered too badly as a result of it taking place electronically. Matt, welcome back.
I'm so sorry about that. I had a mini heart attack because the internet has gone down, and I've managed to scrabble and find a dongle and connect the dongle to the laptop and download all the software, and here we are. I'm so sorry. How far had you got to on your own?
Well, I was wondering whether I was just boring you, which is quite possible, of course. But basically, I completed providing an answer to your question about Patricia Rounsfield.
Mm-hmm.
I then thought I'd ask myself a question about mediations and how that worked. I was about to answer some questions, but I'll come back to the questions in a minute. So I think it's now time for you to do some more talking, Matt. So if okay, I'm going to ask you some questions, and fingers crossed your dongle continues to work. But basically, the question I'd like to ask you, I think I'm going to ask you about key limits on commercial landlords, if I can, in light of the obviously the COVID situation.
Yes, sure. So for this, we need to go back to our old friend, the Coronavirus Act, which is old in lockdown terms, but not in real life. Section 82 imposes several restrictions on commercial landlords, again for the relevant period, so the 26th March to the 30th of September, are essentially 4 limits on commercial landlords. So firstly, a landlord can enforce the right of re-entry for non-payment of rent, either in court or out of court. And the important thing to bear in mind here is that the Act defines rent very, very broadly. It's defined as any sum a tenant is liable to pay under a relevant business tenancy. So that includes things like service charges, insurance contributions, and VAT. The second restriction is that if a landlord has already started possession proceedings for the non-payment of rent, then the court cannot give a possession order requiring the tenant to leave before the end of the relevant period, i.e. before the 30th of September. The third restriction is probably further sweeping. If a court has already granted a conditional possession order requiring the tenant to leave before the end of the relevant period, unless they do something, then in the High Court, the tenant can apply to extend that deadline past 30th of September. But in the County Court, the deadline is extended automatically. In other words, they just don't have to leave until the 30th of September. And the fourth restriction is that where a landlord's opposing the grant of a new business tenancy on the grounds of persistent failure to pay rent, the court must disregard any failure to pay for the relevant period, i.e. the COVID period, 26th of March to 30th of September. Now, in my view, the key question here will be the scope of these rules. In particular, Section 82 applies to business tenancies, we know what they are, but tenancies which would be business tenancies, and I quote, if the relevant occupier were the tenant. Now, it's not entirely clear who this covers, but one good example is perhaps head tenants who aren't in occupation. But the wording is in theory broad enough to cover tenants at will and even potentially licensees who have no independent business tenancy rights of their own. It's also arguable that these rules will apply to tenants under contracted out business tenancies, because the contracting out provisions technically only exclude sections 24 to 28 of the Landlord and Tenant Act. It doesn't exclude the entirety of Part 2. So the short point is these restrictions are fairly sweeping. That said, though, it's not all bad news for commercial landlords. So if you're advising them, they've still got 5 things they can technically do. Firstly, they can bring a debt claim against the tenant or a guarantor. Secondly, they can exercise the commercial rent arrears recovery process if there's more than 189 days of rent outstanding. Thirdly, they can draw down on a deposit. Fourthly, they can bring a forfeiture claim after the 30th of September for non-payment of rent. Technically, commercial landlords can still start forfeiture proceedings at any time for breaches of other clauses in the lease. So, for example, non-alienation or use. Although you might find that in reality, courts are very pro-tenant right now, even though there's no strict rule preventing commercial landlords doing this. So there is still scope for commercial landlords to take some steps now.
Yeah, and actually speaking from experience on that, I've a matter where we're trying to enforce a possession order, the rules don't preclude you from making an application to enforce, which will be stayed until obviously after the restrictions are lifted, but the court has simply returned the application to say we're not going to deal with it. You need to reapply when the stay is lifted. And I went back and said, well, when you look at the wording of the practice direction, actually we are permitted to make the application. And then we received the bog standard response from the court, which is, well, our guidance says the following. So beating my head against a brick wall on that one. So I think it's a case of diarising when those deadlines expire and being ready to go. Looking at more sort of practical day-to-day stuff, what's it like at the coalface? What are the remote hearings like? And have you got any tips for our listeners?
Yes, so in my experience, remote hearings vary from the very familiar to the completely new. So at one end of the spectrum, many smaller county court hearings are simply being run as telephone hearings. Now, this is fairly common to, I imagine, pretty much everybody on this webinar. But at the other end of the spectrum, more substantial disputes like larger applications and trials, and a lot of matters in the High Court, are frequently being run as Skype hearings. These are a little bit more unusual because although you're suited and booted with all the usual paraphernalia like blue books, white books and papers, you're sat in your lounge staring at a picture of the judge sat in their lounge in front of their net curtains. So it's slightly unusual. But coming to practical tips, for any remote hearing, my main piece of advice is to try to prepare as much as you can in advance. And there are 3 particular ways you can do this. So firstly, several judges have said they find it useful to have longer skeleton arguments for remote hearings, more like written submissions. So consider quoting key parts of statutes, cases, or documents in your submissions, rather than simply providing cross-references to the authorities bundle or the trial bundle. Practically, this also makes it easier for the judge to use your submissions as a crib sheet if they want to give an extempore judgment in your favour. And anything you can do to help that is obviously a good thing. Secondly, if you've got any witnesses to handle, you could consider writing fuller witness handling notes, i.e. cross-examination notes or examination in chief notes, because it's inevitable that as soon as you get to the key point of what you want to say, the judge's internet will lag or the opposing witness's internet will drop and you'll have to try and start again. And if you don't have a detailed roadmap of the steps you wanted to take in order, it might be a bit difficult to get back into your groove very easily. For example, when you've run off to find a dongle to see if you can connect to the internet again. The third tip I'd suggest is trying to send off everything you can as far in advance as you can. So I've had several remote hearings where the litigant in person on the other side has said they didn't receive anything, even though we sent it to them days in advance, and they've still asked for the matter to be adjourned, inevitably for months. Fortunately though, if the judge can see that the email to the court filing everything was copied to the litigant in person and was sent several days in advance, then you can avoid any unfounded complaints about your client. You can actually bolster your client's credibility. But to get the most out of this, you must make sure you try and send as much as you can. So not just the authorities bundle or the trial bundle, but things like skeleton arguments, cost schedules, draft orders, and so on.
Okay. Looks like Matt's paused for thought there.
And then once you... Oh no.
Your connection's dipping in and out of there a little, Matt. Sorry. Carry on.
Am I back?
You're back. Just about.
The dongle's not reliable enough, I'm afraid. My final tip was going to be for the hearings itself, just remember that Skype hearings take longer. Virtual bundles are not as easy to navigate. Ministry of Justice computers are slow, and internet connections and dongles apparently keep dropping out. So do factor that in when you're deciding what you want to say.
Fantastic. Good.
Now, thank you very much. I think thanks to my unfortunate departure, we've kind of run out of time. Now we've got a question here from an anonymous attendee, and I'll read it out and then Mike or I can offer our thoughts. It says, following the recent appeal decision, just to confirm, is it the gas safety certificate that was in place before the tenancy is commenced that must be served before service of a Section 21 notice, and not just to ensure the tenant has a copy of the current certificate if that's different? So I think the essential question is it the original one that matters, or is it the updated one that matters?
So this, my understanding of this decision is that, I mean, this looked at the situation when a certificate had been obtained but not served pre the tenancy starting. I know the judgment does touch on the situation when you've got subsequent certificates. It comments on that. I can't remember the details off the top of my head, but there is a part in the judgment that deals with, well, what happens when you've got a need for a certificate to be obtained, you know, the annual check basically, and it's not done within time. can that be perfected? And I think the general position following the decision is that yes, you can, providing again you do it and you give the certificate before you serve a Section 21 notice. So does that answer that question? I'm not sure necessarily it does. I think best practice will be to make sure that they have as much as you can give them, really. You know, if in doubt, provide the old certificates if you have them, if they were obtained in time, and always provide subsequent certificates pre-service of any Section 21 notice if you're able to.
So one of the concerns that had been raised on behalf of the tenants was that this rule is designed to protect the safety of tenants. And anything you can do to show that the property was safe throughout, I think can help bolster the landlord's position, because you can say, okay, we didn't necessarily comply with the rules exactly, but the tenant was safe, and that's the most important thing.
Yes, yeah. I mean, the interesting thing in the Trecarrell decision, of course, is that there were no gas appliances in her property at all. So that's the sort of ludicrous thing about it. But yeah, ultimately this is about safety. Serena asked the question, in light of the Law Commission's suggestion that properties should not be sold as leasehold, do either of you see this realistically happening in the future? I think there's a lot of, there's a big appetite across the public for there to be change, actually. I think this will happen at some point. It's a question of timing. Obviously, I think the government's hands are pretty full at the moment. Parliament is awash with legislation dealing with other things, but this is something of real importance, and I think there is a big appetite for there to be a change to basically to stop fat cat freeholders extracting extortionate sums. Yeah, I think there will be a change in the future.
I would agree. We've just received a question from another anonymous attendee. What are the grounds to evict a tenant? Do they always have to let the tenant continue living unless they have to move in themselves? Now, no is the short answer. So I'm going to limit myself to what's the most common situation. So assured short-hold tenancies, assured tenancies. You've got the grounds in Schedule 2 of the Housing Act. But I thought I'd mention here the Rented Homes Bill, which was introduced in Parliament in substantive debate, but it does set out some potential changes to Schedule 2. Now, it suggests that there might be two new grounds. Firstly, the landlord intends to sell the property for market value to someone who's not connected to him. And secondly, the landlord's family member intends to live in the property. So those would be new. And on top of that, Schedule 2 is slightly amending to broaden the existing grounds. So a very specific one is Ground 5, which means the land is intended to be used for the occupation of a religious minister to carry out their religious ministry. Now that's going to be broadened to simply saying use for religious purposes. Now I'm sure there'll be debate over the scope of that, but in my view, the clear aim is to slightly broaden some of the other grounds. So do keep an eye on that piece of legislation over the next year or so, because that's where things might change.
So there's thank you for that, Matt. I think we've got time for one more question. I think the last question there is probably a good one. Has the 4-week minimum protection from eviction notice requirement been extended by the emergency legislation? I think what we're looking at there that's the Protection from Eviction Act, restrictions requiring a minimum notice period being provided. I actually don't know the answer to that off the top of my head. Just thinking that through, obviously the Act, the Coronavirus Act deals with proceedings under Section 21 and Section 8. The Coronavirus Act may or may not deal with it, but the issue that all residential occupiers or residential landlords are faced with is the fact that the practice direction puts a kibosh on court proceedings. So whether or not a notice can be served. In fact, the current situation is that possession proceedings cannot presently be prosecuted. And there is a degree of overlap between the two pieces of legislation, a bit like a Venn diagram, I suppose. There are bits that are double covered, and there are bits that are covered by the practice direction parts which are covered by the Coronavirus Act. That's probably all we've got time for, isn't it, Matt?
Yes.
I've got one question. Am I in a builder's room? I have to take that question. I'm not in a builder's room. I'm in my workshop, or at least I'd like to think I am. There is a drink over my shoulder, which I can assure you has not been touched this morning. No, this is where I like to retreat to run away from my small children.
Brilliant. I'm not sure if you can still hear me, Mike. I think my connection is unstable again, so I will quickly say goodbye while I can. Thank you very much for joining us this morning, and thank you very much to Mike Ellis, Senior Associate at Wilson's, for kindly giving up the time to talk to us all this morning. Thank you, Mike, and thank you, everybody.
Thanks. Thank you, everyone.